Good afternoon, everyone, and welcome to another webinar from the TUC. My name's Anna, and I'm from TUC Education. And you'll see I'm joined by three speakers today who I will, you'll hear from them in a second. Just quick intros. We've got Clare Armstrong from the EHRC. We've got Kirsty Stanley, who works with people who have long COVID. And we have Damien McNulty from the NASUWT. Over to them in a minute, but just a little bit of housekeeping. As always, we've got live captions on this webinar. If you want to follow along with those, please click on the green button, which is under the video screen that says live captions. That will open a new window with those captions. We, as always, are taking your questions. So if you would like to ask a question to one of our speakers, please post it in the pop-up box that says ask a question. It's right down at the bottom of the screen. And we'll try to get to those after our presentations. And it's great to see so many of you already introducing yourselves in the chat panel on the right-hand side. Please use that space to exchange some ideas and tips that you might have about the subject. It's always great to hear what's happening in workplaces. So today's session is about supporting workers with long COVID. We know that long COVID is becoming an increasingly bigger issue throughout workplaces, and we know that you as union reps have a key role in supporting colleagues who might need to make adjustments, or you might just want to find out a bit more to find out what you can do in the workplace. So as ever, we're recording this and we will be sharing a link of the recording with everyone who's registered later today. And we'll also share any resources that our speakers talk about during the session. So our first speaker is Clare from the EHRC. I'm just going to get her to introduce herself first, and then we're going to hear from her and a little bit about what long COVID is and the law behind it. So Clare, over to you.
Thanks very much, Anna. Good afternoon, everyone. My name's Clare Armstrong, and I'm a solicitor in the litigation and advisory team with the Equality and Human Rights Commission. So with those of you that aren't familiar with our organisation, we're basically the UK's regulator for equality and human rights, and we provide advice and support to individuals and employers in respect of those issues. Today, I'm going to be giving you the legal perspective on the Equality Act definition of disability and what it means for long COVID. On the next slide, I've set out a brief summary of what I'm going to cover today. It's a very whistle-stop tour, but it's focusing primarily on the Equality Act definition of disability, the different components of that definition, and also then we'll touch upon what evidence you might want to produce if you're trying to prove to an employment tribunal that someone with long COVID has a disability, and looking at a couple of tribunal judgments in that area. So moving on then to the next slide, the Equality Act definition of disability is a physical or mental impairment that has a substantial and long-term adverse effect on a person's ability to do normal day-to-day activities. Now, not all cases of long COVID will meet this definition. One of the key issues that crops up quite regularly is how long somebody has had long COVID. We all know that some people might have it for just 4 to 6 months. Other people can have it for years. And that is something that's quite difficult in this area. But it's important to remember that you don't have to have any kind of specific diagnosis of long COVID as such. You do need to have tested positive for COVID, but the focus is really on the effect that the impairment has on day-to-day activities. It is important also to be aware that from a legal point of view, disability will be assessed at the point discrimination happens. So when someone is dismissed, when they are treated badly, not at the date of some later hearing or something like that. And we'll look further at the importance of that when we're looking at the tribunal judgments at the end of this session. Moving on, then, I'm going to talk now about the different parts of the definition of disability and what they mean. So a disability has to have a substantial adverse effect on day-to-day activities. Now, substantial means more than minor or trivial. This is quite a low threshold to meet, really. So, for example, if you used to be able to walk 10 minutes down the road to go to the shop, and now you can't make it and you have to drive, that is substantial. If you're having any treatment for the condition, any medication or anything like that, that will be discounted. So you need to look at what impact the condition will have, taking away any effect any medication or other treatment might be having. Normal day-to-day activities, there is some really useful guidance that mentions this, and also loads of other really helpful points in relation to the definition of disability. And it's what I've mentioned on this slide, it's government's formal Equality Act guidance on disability, and it does explain what normal day-to-day activities can be. There's some examples set out on that slide. Moving on to the next slide. Long term. So a disability has to be a long-term condition, and as I mentioned at the beginning, this can sometimes be problematic for sufferers of long COVID when they're legally trying to prove that their long COVID amounts to a disability. And that's because the condition has to have lasted for at least 12 months or be likely to last for at least 12 months. Now, in legal terms, likely means that it could well happen, and that's not that high a threshold to meet, but you do obviously have to have some kind of basis upon which a tribunal concludes that it could well happen that this condition is going to last more than 12 months. Moving on to the next slide, we're going to talk a bit about fluctuating conditions. So we all are probably aware that a lot of people that suffer from long COVID, their symptoms fluctuate. And the Equality Act has some specific provisions that deal with what they call recurring conditions. And that basically means a fluctuating condition. And the quote that I've put out at the top of that slide there is basically the Equality Act's definition of a recurring or a fluctuating condition. Now, the important thing to bear in mind here is that if somebody is suffering from short episodes of an illness, they're each less than 12 months, what the tribunal needs to consider is whether these episodes all form part of an underlying condition, and therefore whether that underlying condition is likely to last at least 12 months. And if it is, then that will meet the Equality Act definition of disability. The adverse effects of the condition, they don't have to be exactly the same each time the condition recurs. So I'm aware that with long COVID, sometimes the symptoms progress. So the symptoms that somebody might have at the very beginning of their condition are not necessarily the same as the symptoms they will have 6 months later. That's okay. That is not going to stop you from necessarily proving this amounts to a disability, but you do need to prove that the different symptoms are linked to that underlying long COVID condition. If we move on to the next slide, this slide is talking about what evidence you might need to gather if you're trying to persuade an employment tribunal that long COVID amounts to a disability. Now, most tribunals will require an individual to produce a disability impact statement. This is basically a witness statement where you set out all of your evidence as to how the condition affects you and why you think it meets the definition of disability. And it's really important to make sure that you put as much information into that statement as possible. Usually it's helpful to have some kind of contemporaneous medical evidence to support the statement. Footnotes can be used, but sometimes they don't have very much information about symptoms. So medical records are usually quite useful. GP records, for example, but do consider if your member is getting advice from other healthcare professionals like an occupational therapist or a counsellor, because those records could be useful as well. I've put question mark after medical report, not because I'm saying you shouldn't get one, but just because you should think quite carefully about what questions you want your medical person to address. For example, if you were to ask a GP to talk about whether they think somebody is likely to have long COVID when they've had it for 6 months, they might feel they're not really in a position to say. And this is difficult with long COVID. It's because of the lack of medical evidence and research around it, because it's such a new condition. But hopefully that will change as time progresses and as we learn more about the condition. Another thing that can be useful sometimes to refer to is credible sources of statistical or research evidence. So, for example, there's some statistics produced by the Office for National Statistics on the number of people reporting with long COVID, their ages, things like that. And I know the TUC has done some of its own very good research on this subject as well. So, those can be useful resources to look at. I'm now going to talk about two tribunal judgments where the tribunal considered whether somebody with long COVID was disabled under the Equality Act. So on the next slide, the first case that we mention is Burke against Turning Point Scotland. So in this case, the tribunal found Mr. Burke's post-viral fatigue syndrome caused by COVID did amount to a disability. I think a key point in this case is that he had been absent from work for 9 months before he was dismissed. So he'd already been ill for quite a large part of that 12-month long-term requirement. His condition did fluctuate, so there were points in time within that 9 months where he felt he'd improved quite a bit and he was thinking about going back to work, but then he suffered a relapse. So I suppose just take a bit of faith in that just because somebody is in that situation, it doesn't mean they can't prove that their condition amounts to a disability. Another thing to note about this case is that Mr. Burke didn't have very much evidence, medical evidence rather, to support his case. But bear in mind that when he had long COVID, it was in the middle of lockdown when we had quite serious restrictions on face-to-face appointments. So his medical notes were quite limited, but obviously the situation is different now. So I think tribunals might have slightly higher expectations on what they would expect to see in medical records. The next case is Quinn against Sense Scotland. Now, this case went the opposite way and decided that the claimant's long COVID didn't amount to a disability at the relevant time. But in this case, the claimant had only had COVID for 2.5 weeks before she was dismissed, and she complained her dismissal was discriminatory. She wasn't diagnosed with long COVID until a later date. So at the point that she was dismissed, there wasn't any evidence at that time that her COVID was likely to last for at least 12 months. As we know, the vast majority of people that get COVID don't go on to catch long COVID. Unfortunately, this lady did, but we didn't know that was going to happen at the point she was dismissed. So what can we learn from all of this? Moving on to the next slide. I mean, the most important thing to remember about these judgments is each case has been determined on its own facts. They don't set any new rules of law or any precedent. They're just applying the existing laws on disability as they already are. There's nothing new in them, really. An employment tribunal is not required to sorry, let me start again there. An individual is not required to have an employment tribunal judgment to be able to treat an employee with long COVID as disabled. So do remember that when you're advising your members. Best practice is for an employer to focus on how they can support somebody with long COVID, not whether their condition meets the legal definition of disability. Obviously, the focus of my talk has been on that definition, and if a case ends up at the tribunal, those are the points that the tribunal will be looking at. But an employer should be thinking, in the same way as they do with anybody that has a health condition, what can we do to help this person? How can we support them to stay in work? So thank you for listening. And if anybody has any questions, I'll be happy to respond at the end of the webinar. And I'll pass back over to Anna to introduce the next speaker.
Thanks very much for that, Claire. I think that was a really great introduction to what long COVID is and the law behind it. We definitely will have time for questions at the end, so please do post them. Our next speaker is going to be Kirsty Stanley. Just while she's getting ready, I'm just going to bring something to your attention that we've got here at the TUC. We've got a survey about long COVID that's running, I think, till the end of this week. And we'd love to hear what's happening in workplaces. It really helps us inform advice and guidance and policy that we put out for workplace reps to help them. So please do fill it in. We'll share the link in the email that goes around later, but we'll also put the link in the chat now. But without further ado, it's over to Kirsty, who is going to tell us about work she's been doing excuse me, with people who have long COVID. So Kirsty, it's all yours.
Thank you very much. So my name's Kirsty, Stanley, my pronouns are she, her, and I am part of a number of different patient advocacy groups. So I have been part of Long COVID Support, which is sort of the national one of the national adult charities for Long COVID. And as part of that, I've been part of their employment support group. And then I am also part of Long COVID Work, which is a consultancy of people with lived experience of long COVID and professional experience around work. And I also do work with Long COVID Kids, a charity as well. So I'd like to touch on some points around the fact that you may be supporting parents of children with long COVID as well in the workplace. And I'm sure that's not something that's perhaps been thought of as much in terms of that they may be needing to miss work to support or care for an individual as well. So I've worked with adults and children with long COVID. I have long COVID myself. I noticed a number of people in the chat do, so my empathy goes out to you for this. I just first of all would like to pick up on something that Claire said in her presentation, just to query that, and maybe Claire can come back and respond afterwards. But you said, Claire, that there was no need to have tested positive for COVID. No, there was a need to have tested positive for COVID, and I would worry about that as a thing, because as we know, there wasn't testing available for a lot of people. So people can get a clinical diagnosis based on signs and symptoms. So I'm not sure if that legal test is correct or not. So I'd be interested to chat with you more about that. Obviously, long COVID is an umbrella term. It's a patient-defined term. And it can encompass lots of different kind of challenges that people are experiencing. So there are a number of sort of co-occurring conditions or syndromes that people may be diagnosed with alongside this sort of long COVID umbrella term. And I know that the NHS are sort of moving towards using post-COVID condition as well as a term rather than long COVID. So you may hear lots of different terms. I really, obviously, as an occupational therapist, want to highlight sort of Claire's points really about it's not about a diagnosis, it's about the impact on somebody's function. So I've seen comments in the chat around there being similarities to ME/CFS or being sort of overlap with menopausal symptoms, etc. So I wouldn't worry so much about the label, but what is the impact on that person's life, and is that then amounting to a disability? One of the sort of symptoms that is quite common with people with long COVID is obviously fatigue and brain fog. So one of the things as advocates we would really push union reps to do is to support staff at any meeting they're going to with sort of HR or line managers, and be there as somebody that can take records, because cognitively people may not be able to sort of retain the information that's being said in that session, and may need a record to go back to. So one of the things I'm quite passionate about is about reducing the sickness administration for individuals, because being sick comes with a lot of extra admin, and when you don't have a lot of energy, anything that you can do as reps to kind of support that is better. And then I think it's worth not getting hung up on what is legal, so what's the law, what do employers have to do, and still try and push them to good practice guidelines. So obviously some of my colleagues did some work with the Society of Medicine about things that could be happening in workplaces to support people back to work. And if you go to our website, Long COVID Work, we link to lots of different kind of resources on there. So it should be a really good resource for you. But yeah, it's about, what can they do, not necessarily even what's been done in the past, but getting employers to think outside the box and retain talent, retain people. So one of the things that we've kind of pushed all the way through is that the standard phased return doesn't seem to work for people with long COVID. So it's whether there can be some extensions of that, or even whether there can be scope for employers to look at work as a form of rehabilitation for their employees. And that is obviously a bigger topic that we won't discuss today. But one of the most important things that I think in terms of advocacy that you guys can do as well is where somebody hasn't been able to access medical support, because we know there is differences around the country in terms of what support people have been able to access, or things like they may have applied for access to work, but we know there's a backlog in access to work, is hopefully pausing employers making long-term decisions until we know what support can be put into place for people, because that may well, obviously, if people lose their job, it sends them into poverty, basically. Okay, and there goes my doorbell. Okay, that's the main points that I wanted to cover, and obviously I'll answer questions and stuff afterwards.
Thanks, Kirsty. Great timing there with you're just finishing.
I'm just going to go and grab the doorbell because the dogs are going to howl otherwise.
No worries. Okay, yeah, thanks for that, Kirsty, while you go and sort the doggies out. Okay, before we look to questions, we're just going to hear a bit from a union perspective. So we've got Damien McNulty from the NASUWT, who's going to talk a little bit about the experiences of members from the NASUWT, which is an education union, and about some of the work they've been doing already over the past couple of years. So Damien, over to you for now.
Thank you, Tanya, and welcome everyone to this afternoon's webinar, and thanks to the TUC for hosting this. It's been really helpful to hear from Clare and Kirsty, and I'll probably pick up a couple of the points that Kirsty referenced in relation to what you can do as trade union activists and staff to support members. NASUWT has been working globally with Education International, and I'm going to probably quote quite a few facts and figures at you this afternoon. They are included in a PowerPoint presentation, which I'm not going to display on the screen, but it will follow this presentation. NASUWT, along with many of the trade unions represented today that I've seen colleagues reference, are campaigning to get the definition of long COVID included specifically in the Equality Act. And we're also campaigning nationally with employers at a school-by-school level, also with local authorities and multi-academy trust employers, for the inclusion of long COVID in their sickness absence policies. I think it's important as well that we look at the prevalence of long COVID in the population. 3.5% of the population report self-diagnosis, or self-report, I should say, long COVID symptoms. That's 12 weeks after first contracting COVID, and those figures come from the start of September 2022. That's some 2.3 million people. Education have the second highest prevalence of COVID after social care, and it's actually running close to 4% of the educational profession are affected, or 1 in 25 employees. But there's a number paradox. Employers are only reporting between 1 and 2% of staff have identified as having long COVID. Now, we've surveyed our members extensively, and we've found that just over a quarter are reporting that they have had long COVID. So when we dig into the reasons why they aren't reporting to their employer that they have long COVID, you'll probably not be surprised to know that a number, and the figures are almost exactly a quarter, for the following 3 categories. Many are afraid of punitive action. Many are worried about future employment or promotion prospects. And another group don't want to have the label. Also, 16%, which is almost 1 in 8 employees, say it doesn't affect their work. It's really important that we get our members to report to their employer if they are experiencing long COVID symptoms, because if the employer doesn't know, then they would reasonably say, well, we don't know what we can do to support staff who are experiencing symptoms of long COVID, whether that's from an occupational health point of view, or changes to their sickness absence management policy, or other reasonable adjustments they may wish to make in the workplace. The employer's responses, and I'm sure many of you will have experienced this personally, vary from best practice, where we've got a number of employers who are more sympathetic to staff with long COVID, because often senior employees have experienced long COVID themselves. And the best are offering up to 6 months of a phased return, rather than what the original sickness absence management policy says. The worst employers, however, if someone's off for a few weeks with COVID, never mind getting to the point where they've experienced long COVID, then they're applying the full force of sickness absence procedures, and they're moving staff on. We've already heard reference from Kirsty about some of those the most common symptoms, and I've seen in the chat group as well a number of comments about what those are. 70% report fatigue, not uncommon in public services because of the hours we work and the work that we do. Not specifically a long COVID symptom, and many colleagues have talked about how other conditions and some of those are part of the life cycle of some members, whether that's menopause symptoms. Other colleagues and attendees have talked about ME symptoms. But it is important that we get these documented, that individuals keep a record of the experiences that they're having. The symptoms are reported to be affecting, from the ONS survey, 1.6 million people in the UK. That's 72% of those that self-report for long COVID or experience symptoms on a day-to-day basis. Older workers have a higher prevalence. There's a third more women than men. Almost certainly because many more work in frontline, low-paid work, where sadly over the course of the pandemic there weren't always the PPE protections in place for those. Our survey results and the ONS results correspond with this, that white populations are significantly more likely to report long COVID, and unfortunately we're picking up from our members that work in particularly in supply for agencies where their employment is more precarious, that there is the potential when they experience long COVID for them to take breaks in their employment, which has a further detrimental impact on their wider well-being, because income then becomes an issue. So what can we do? What can we do as trade union officials? What can we do proactively to raise those issues with our employers? Well, we need to have those conversations with our members in our workplaces when we're having branch meetings, and many of us are currently engaging with our members around balloting for action and the cost of living crisis. We need to capture first-hand experiences and share those with employers in an anonymized way, so that they fully understand the implications of what it means for colleagues in your workplaces on a day-to-day basis, or what it can mean. And we're calling for statutory recognition, as I've already said, for the definition of long COVID to be included in the Equality Act. We need to challenge educational employers to support staff experiencing long COVID, guarantee them access to decent sickness absence provisions. And why would employers want to do that? Why would they want to extend the provisions of their current policy? Well, we hear regularly in the news and in the media that we're almost at full employment. There's an organisational cost for any employer to recruit staff, to train them. I hope gone are the days when if employers wish to move on staff, they've got a ready stream of people queuing at the door. I think from the employment figures that we see, that's less likely to happen currently. The number of vacancies in social care and in many other frontline professions speak to the fact that it's difficult to recruit and retain staff. So there's a positive benefit for employers to review and revisit their sickness absence procedures. The joint unions that represent education, I'm going to name check a number of unions that are here today, and Tanya from TUC will share this document with you. It's a 4-page document. Those of you that work in education, I hope have already seen it. It's a joint protocol that we're putting in front of employers around the management of long COVID. And that's a joint protocol from colleagues in the National Education Union, NEU, ourselves at NASUWT, ASCO, which is the Association of School and College Leaders, the National Association of Head Teachers, Unison, GMB Unite, and also Community. It's a really fantastic document. And of course, the better employers are signing up to that. And one of the pressures that we can put on neighbouring employers, neighbouring schools, neighbouring multi-academy trusts in England, for sure, is to name check the good employers and to share that with our members to say, these are employers that are making reasonable adjustments, that are treating their staff with respect and dignity. And one of the points that Kirsty mentioned is covered within the joint protocol. And that's to recognise that parents will be supporting children or have carer responsibilities for others in their wider and immediate family circle who may well have long COVID. I'll conclude there, and I look forward to hearing your questions. Thank you.
Thanks for that information, Damien. It's always interesting to hear what is happening in unions, and specifically in your union, the NASUWT, to find out what's happening in your sector in education. Something that came up in the chat that I want to put to you all first is when you were mentioning a few minutes ago, it was you, Damien, you were mentioning about sickness absence policies and about how they perhaps need to be reviewed. Someone suggested that employers could implement a specific long COVID policy or COVID policy. So if this is something you think would be good, well, that's my first question to you. Do we think employers should do that? And secondly, what sort of things should reps be thinking about including in a policy on long COVID? I'll let you have a little rest for a minute, Damien, because you've just been talking, and perhaps we'll go to Kirsty and Claire first. So Kirsty, can we just start with you? Just a couple of things that you think might be good here for reps to think about.
So the first thing I would say is that sickness absence policies don't tend to work for people with disabilities anyway. So to say that we need a specific long COVID absence policy is a bit of a misnomer, really, because I think we need to just get better at supporting people with disability within the workplace, especially when they have these episodic or fluctuating conditions. Obviously, if there was a specific policy, I think it would need to look at the episodic nature of the condition, the fact that it can get worse at times, the fact that we need to be supporting employees to have a good quality of life outside of work as well as within work, which I think is a really important point. So Damien kind of mentioned that, some people don't disclose because it doesn't affect their work, but I bet for most of those people, it affects their weekend and their evenings if it doesn't affect their work, because they're putting everything into work and having no resources basically left over. And people can do that for a short time, but what will happen over the longer term is they will start having more sickness absence, their fatigue will get worse, they will make mistakes at work potentially in terms of cognitive challenges. So I think, making sure that people are getting that balance early is really important. And probably the biggest one that I would say is also sort of paid time off for medical appointments. Because there is a lot of different specialities that people perhaps need to access and see, and if they're having to take unpaid time to do that, then that's going to disadvantage them further.
Thanks, Kirsty. Really interesting. That's why I posed the question, because I thought there'd be some really good opinions here. Is there anything you want to add, Claire, before I move on to Damien? One sec. So you were just on mute. Sorry, you're all right now.
Sorry, I'm on now. Yep, no problem. Kirsty has just said a whole host of really sensible things there. In terms of the fluctuating nature of the condition, I think quite a lot of employers might have sickness absence policies that act on like either a trigger basis or, you know, maybe episodes of sickness or something like that, and however many episodes you might have, it might trigger some kind of formal action. And so I suppose if they were looking at supporting people that have long COVID, what they'd probably want to do is make sure that formal action isn't triggered so quickly. It has to allow for the fact that maybe they're going to have episodes off work periodically every now and then, and the employer shouldn't be jumping to just take formal action against that person. And then another thing Kirsty was touching on was the sort of fatigue issue, and people that say, oh, long COVID doesn't affect me at work. Maybe if there was going to be a specific policy about long COVID, which, as Kirsty pointed out, there doesn't have to be, but if there was, maybe that policy should include something about sort of reviewing somebody's working pattern or working arrangements. You know, maybe they need a different mix of, if possible, of home and office working. Maybe they need shorter hours. And so that's not directly about sickness absence, but if you get those things right, then it might mean that the person doesn't need to take as much time off sick. So it's all kind of linked in with each other. So really, I think if you were looking at a long COVID sickness policy, you can't really look at that in isolation. You need to look at all the other things that need to be done to support the person. Because if they're supported properly, hopefully they won't have as much time off.
Thanks, Claire. And I think you touched on something there that we always say about the role of the rep is that we appreciate that reps are really busy and they take on a lot of extra tasks, and we all know that you're volunteers as well, but often having that holistic view of the workplace and looking at all the different factors is more helpful than looking at something in sort of specific isolation and trying to deal with one particular thing, whereas if you look at things in the round, you'll perhaps get a better perspective. Damien, have you got any examples of policies, not necessarily a long COVID policy, but policies that have been adjusted within the NASUWT that you're able to share with us?
Yeah, for sure. A number of local authority employers and multi-academy trust employers have made those changes, many of the changes that Clare and Kirsty have talked about. And when I mentioned sickness absence policies, there's an array of policies that link in together that sit alongside sickness absence policy. For example, you could sit outside it around leave of absence. Kirsty rightly talked about paid time off to attend medical appointments. You know, that shouldn't be part of either. People shouldn't have to take annual leave or to have that count against any trigger periods within a policy. We've also seen upfront addendums being added to sickness absence policies, for example, to extend periods of full pay or the half pay periods as well for those that have experienced long COVID. Also, the upfront inclusion and many sickness absence policies haven't been revisited for many of them haven't been revisited for decades. And things like including a health and safety risk assessment, which will enable an employer properly with the support of where we have them, workplace representatives and the individual, to identify those adjustments, those reasonable adjustments that Clare talked about in relation to work location, maybe work pattern. A good employer will seek ways to find those, and also adding in extended phased return periods. Good employers do and will extend those phased return periods and not have a hard cut-off point that in many sickness absence policies will define a period of weeks. And at the end of that, if you're not able to return to full duties, then other processes and procedures may may flow from that, whether it's medical incapability or a move into other disciplinary procedures, depending on how things lie. Also, the inclusion actually of the concept of having sporadic attendance that links with the condition, and good employers do this already around recognised disabilities, that if there are trigger periods, that any absences associated with that disability, or in this case long COVID, will be disapplied from any triggers. So there's a whole range of options there, and all of those are included in the joint protocol that I mentioned. And I'll just conclude by saying, and a colleague I didn't catch all the comments, but one colleague said that he noted that UCU were absent, University College and Union were absent from that list, because these are the recognised trade unions for primary and secondary schools where this protocol has been sent, not for higher education. That's the only reason that they were absent. Thanks.
Thanks for that summary, Damien. Okay, another question we've had is about, do the members of the panel know of any training that is aimed at employers about understanding long COVID and the things they need to be thinking about? I mean, I imagine there's a lot of training out there, but some might be different quality. If you know of any, maybe like nod at me now, and we can come to you and maybe mention it briefly, and we'll send links out afterwards, because I don't think we've got time to go into a big discussion of training. But does this kind of thing exist? Do we have anything we might want to share with reps so that we can they can encourage their employers to take a look at it? Kirsty, you waved at me, so let's hear from you.
Yeah. So obviously that's part of why long COVID work was set up, because we are all we're living with long COVID, but also have the employer. So we've got 2 occupational therapists, a HR specialist, a union person, and an occupational health physician in our group. So we have done work with employers and are willing to do work with employers. And there are other, somebody called Christina, I think, mentioned the fact that obviously there is some overlap with MECFS. So a lot of the training that is applicable to there may also be able to be crossed over to long COVID as well.
Thank you. Thanks for that. That's really helpful. We'll send some links to your organisation and other resources in the follow-up. Okay, we've had a question asking about freelance workers, agency workers, precarious employment, and what can be done to protect them. I mean, I appreciate this is this applies to many workplace issues and not just long COVID. We often ask this about, whatever we're discussing. So I'm wondering what advice we can give to people who might have freelance or agency workers in their workplace. I mean, you already mentioned it a little bit, Damien. Yep. So should we maybe go to you first, Damien, talk about schools, and then I'll come back to Kirsty and Claire.
Yeah. Sadly and unfortunately, the ever-increasing gig economy, 0 hours, agency workers, that whole family and plethora of precarious employment comes with it virtually no employment rights. Claire will, I'm sure, have something to add here, but it's the statutory provisions around sick pay that will apply, and that will be the minimum statutory provision. And because there is no employer-employee contractual link, there's no obligation on any employer to undertake those. To reach out to provide that support, and unfortunately, it's those individuals will be left to their own devices. Sadly, we did see during the height of the pandemic that local authorities were provided with additional funding to assist individuals that were in more precarious employment that were experiencing financial hardship. And there were a number of industries particularly affected where there was a high prevalence of those of individuals working in precarious employment. It's incumbent upon us all to campaign for agency worker rights and the agency worker regulations to be strengthened and to be bolstered, because it does affect members of all of the trade unions that are represented today, sadly.
Thanks, Damien. I'll come to you first, Claire, and then over to you, Kirsty. Just any thoughts about agency or freelancers?
It is really difficult because, as Damien's already pointed out, certain statutory rights won't necessarily apply to them. I mean, for a lot of workers, they are still protected from discrimination under the Equality Act. You don't have to be an employee, you just have to be what's called in employment for the purposes of the Equality Act, and it is a wider definition. You'll only not be protected if you're a truly self-employed person, and then you wouldn't be protected as an employee. But you know, that's not really too much comfort, I suppose, for somebody who's just ill and can't go to work and isn't entitled to sick pay. And it's a problem that exists in the gig economy, as we all know. And I'm afraid there is no magic answer to it at the moment. But as I say, people are protected from discrimination. So at least that's one right that they do have.
Thanks for that, Claire. And Kirsty, anything to add?
Yeah, so I went self-employed just before I got ill, and that has been a challenge. I mean, luckily I have been able to work from home, and that is probably the only reason I've been able to keep working. If I had to go to a workplace, there's no way I would have managed that at times during the last couple of years. But equally, in terms of I did some 0 hours contract work during that time, and had to fight battles, let's say, around disability support, etc. So I'm well aware that it is really, really challenging. And I think one thing that you could do as reps is just make sure that people are claiming any benefits that they're able to help them financially. So PIP obviously is the main in-work benefit that people can use, and obviously if not, it's whether they are eligible for sort of ESA or universal credit and stuff as well.
Yeah, thanks, Kirsty. That's a really good point. It's that often reps are there to help signpost and provide further information and guide their members through if they might need to make a claim. We've had a question that I'm going to throw a bit of information at, saying how do we organise collectively on these things so that it's not down to the individual to sort of solve their own or to tackle their own issues on this. And I think we can apply the advice we give reps in lots of situations, really, about, you know, how we can organise collectively. I think all three speakers have mentioned about talking to members, bring this up at meetings so that you can then talk to management about it. Because if you're not hearing the information, you've not got evidence, it's not an issue you can raise with management. And we say that about any workplace issue, don't we? It's about getting the information and using it to make a case to management to try and get adjustments made. And that sort of leads into another question we've had posted, which is about reasonable adjustments and specifically what some examples are, really. So I think often people think a reasonable adjustment might be a reduction in amount of time, but can the panel discuss some ideas for reasonable adjustments for maybe full-time posts, for example, education or healthcare, where it's not as flexible? So, you know, you've got much more set hours rather than that flexibility. We'll come to you first, Damien, because you can talk about education, and then we'll think about the other sectors that are similar to that.
Yeah, and I will confine my comments to education. As a former primary teacher for 25 years, full-time teacher, I can absolutely understand why someone would ask, well, what would a phased return look like for a full-time teacher, whether they're primary, secondary, or anywhere else? Well, it can look like, and there's not hard and fast here, but quite a large amount of work that teachers undertake is around planning, preparing, and assessing, and doesn't need to directly be in front of the children. Now, clearly, if there's a class of children to be taught, there needs to be a qualified teacher in front of them. So there are a number of ways that that schools found during the pandemic, particularly during the height of the lockdowns, to work in a hybrid manner. Whether that was teachers dialing in remotely because they were extremely clinically vulnerable, providing resources, materials, or support in a virtual way to other teachers that were present in the classrooms. That's certainly possible. There are a number of activities that take place in a school environment that can be done remotely, but also the capacity to a reasonable adjustment, the capacity, particularly if someone's experiencing fatigue, to be able to take a break, to be able to have a space to go, to sit down that's comfortable, that's well ventilated, where they can get a drink, and having the capacity to do that across the wider staffing group, even just for 10 or 15 minutes, could be the key to getting through to lunchtime or to the end of the day. It doesn't need to happen all the time. And what we found over the last 10 to 15 years in schools is that the education workforce has increased dramatically. And many of us might think back to our own childhood days where the only adults you saw were the teachers in a school. That's certainly not the case anymore. And there are a larger group of wider educational professionals working within schools that can provide those opportunities to support breaks during the day, as well as potentially remote working. Thanks.
Thanks, Damien. There's some really good suggestions there for the school scenario for education. Let's just think about other. I use healthcare as an example, but there are other workplaces where it's less flexible. Let's go to you first, Kirsty. Any practical examples of reasonable adjustments that we can make in that kind of employment?
Yeah, practical examples are my middle name. Occupational therapist here. That's what I'm here to do, really. Obviously, don't forget access to work would be the first thing. As people may be able to get support from access to work. So one of the common adjustments that I request for people with long COVID or any sort of energy limiting illness is the potential to get taxis to work. So actually cutting out that travel time. Also getting, just little things like getting a more supportive chair that means that they're not fighting fatigue because they're comfortable and they're not in pain and everything like that. Obviously around cognitive issues, there can be, they get a supportive period of time to almost make like a checklist for regular tasks that they're doing, so that they've got a cognitive prompt to go to, and it may be that they get additional supervision or sort of workforce management support along that, so somebody checking in that they've kind of got their priorities for the week and they know what they're doing. That will depend obviously on each individual and whether they need that, but that would be a really good thing to kind of promote as standard. And obviously in the interim phases, it could be shadowing people, co-working, those sort of options, so that you've got you're not having to take on that responsibility wholly yourself until you feel confident in doing that.
Yeah, thanks, Kirsty. Some people are saying that the information suggestion about taxis is a really good one. I think, if you can cut down on that interminable commute, it is often a real big help, isn't it?
Yeah,
especially
driving is one of the most cognitively demanding activities that we do, I think, as humans. So
absolutely,
people are exhausted when they get to work, let alone then actually getting to do it.
They haven't even done anything work-wise yet. They've just got there. Okay, Claire, have you got anything to add about reasonable adjustments, either practical examples or any sort of EHRC opinion on this that we can hear as well?
I mean, the practical examples given there by Kirsty and Damien, to be honest, you've given loads of practical examples, so I'm not sure I can add any more to that. I suppose just to add that what's reasonable is going to depend on the size of the employer and the resources that's available to it. And whilst it means some adjustments can be difficult for smaller employers, the converse of that is, if you work in a big hospital as a nurse or something like that, like they should be able to make changes to shift patterns and put in extra supervision and give extra, because they have a lot of staff. Like, I'm not saying there aren't difficulties in achieving these things because people are allocated their teams and their responsibilities, but these problems are not insurmountable. And I think that, there's a higher burden on larger employers to do more, basically, because what is regarded as reasonable, it'd be reasonable to expect them to do more because they have more resources available to them. So just bear that in mind as well.
Thanks, Claire. Yeah, there's a few people been asking about who pays for taxis. I guess there is a suggestion it can be paid by Access to Work if an individual employer isn't able to fund them. But there is a link, I think, to the various different ways that people can claim for this. So yeah, there are resources available to help explain that. Okay, so we've covered quite a lot in the webinar today about, I think, a really interesting subject. There's lots of strands to it. The practical suggestions, which we're delighted we've had Kirsty to help explain some of those, and the legal underpinnings from Claire, and the workplace and union experience from Damien. So it's been really interesting hearing from you all. We do also have some e-learning about long COVID, and that has been shared. We'll share that again about stuff that you'll take a bit longer for you to read through in your own time, but you can keep referring back to it as a resource for when you're supporting members in the workplace, either individually or, crucially, collectively. And we also would remind you that the TUC has a survey open till the end of this week, where we're gathering information, evidence and experiences of long COVID. So please do fill that in. The more information we get, the better we can campaign, advise and develop policy. So thank you to Claire, Kirsty and Damien for joining me today. Thank you all for joining. We've got another webinar, I think, next week. So do join us for that. More details will be shared soon. And have a good rest of the day and end to the week. Bye-bye for now.